Code on Wages 2019. The Code on Wages subsumes four central legislations: Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. Refinement in the concept of wages and the principle of no discrimination. Wages means remuneration payable to an employee on fulfillment of terms of employment in respect of work performed by him. It includes basic pay, dearness allowance and retaining allowance, and other entitlements under any scheme as per law in force. But it doesn't include bonus, value of accommodation, reimbursement of special expenses, gratuity, HRA, and overtime. In Regional Provident Fund versus Vivekananda Vidya Mandir, Supreme Court laid down that while calculating Provident Fund contribution, special allowances have to form a part of the basic wage. The relevant pay has to include basic, DA, retaining allowance, value of food concession, and special allowances which are paid at fixed rate for education, conveyance, telephone, etc. But variable allowances which are payable only to particular category of employees need not have to form a part of basic wage. The code stipulates that the proportion of other than basic DA and RA in the remuneration should not exceed 50%. It stipulates the contribution towards Provident Fund and gratuity has to be based on a minimum of 50% of total remuneration. The code stipulates no discrimination in matters relating to wages on the basis of gender, and in respect of work of a similar nature, it demands that no discrimination should be made on the grounds of sex while recruiting an employee and also in the condition of employment. The code specifies the concept of minimum wage, its fixing and revision, and also floor wage fixed by the central government. Minimum wage is the living wage which guarantees subsistence and preserves efficiency. It is enough for basic standard of living involving health, dignity, comfort and education. And unorganized sector is always deprived of living wages. As held in Asiad workers case, paying less than minimum wage is an offence, and Article 23 of the Constitution prohibits beggar and other similar forms of forced labor and makes them punishable. The three components of minimum wage are basic, cost of living allowance, and cash value of concessions. Cash value of concessions arises on supply of essential commodities at a concessional rate. A committee or subcommittee formed by the appropriate government holds inquiries and advises the government, based on which government forms a draft proposal and notifies in the official gazette. It invites objections from those who are affected within next 2 months. After 3 months from the date of notification, the government incorporates accepted changes and puts the minimum wage into force. The appropriate government is required to review the minimum wages at intervals not exceeding 5 years. In every specified employment, the appropriate government shall fix the minimum time rate, minimum piece rate, and the overtime rate. It will also fix the period for wage by hour, day, or month as appropriate, and the government will ensure that where an employee works on piecework, he also gets minimum rate of wages on a time work basis. Central government has the power to fix floor wage considering minimum living standards of a worker. It can fix different rates for different geographies. The rate fixed by the appropriate government shall not be less than the one fixed by central government. Concurrently, the appropriate government cannot reduce its wage when it is higher than the floor wage fixed by central government, and central government on its part obtains advice from Central Advisory Board and also consults appropriate governments before fixing the floor wage. Where an employee works on 2 or more classes of work which carry different minimum rates, he shall be remunerated on the basis of time occupied in each class of work. And where an employee is engaged on piecework but no piece rate has been fixed, it shall be ensured that he is paid at a rate not less than the minimum time rate. In respect of payment of wages, the code makes provision for hours of work, overtime, mode of payment, wage period, time limit, deductions including fines. The appropriate government fixes the number of hours for a normal day with one or more intervals. It shall also provide a day of rest with pay every 7 days, and it makes provision for payment for any work done on a day of rest at a rate not less than the overtime rate. Where minimum rate has been fixed by the hour or by the day, etc., and the worker works on any day in excess of the normal number of hours, the employer is bound to pay for every hour or part of an hour in excess at the overtime rate, which shall not be less than twice the normal rate of wages. The code stipulates that all wages shall be paid in coin, notes or checks, or by credit to bank account or by electronic mode, and the appropriate government can specify payment of wages only by checks or by crediting to bank account in respect of specific industrial or other establishments. The wage period as fixed by the employer can be as daily, weekly, fortnightly or monthly, but it shall not be more than a month. Different wage periods may be fixed by the employer for different establishments. In respect of daily wage period, wages to be paid at the end of shift, weekly before weekly holiday. In respect of fortnightly wage period, before end of second day after end of fortnight, and in respect of monthly wage period, it has to be paid before expiry of 7th day of succeeding month. However, wages are payable within 2 working days in respect of removal, dismissal, retrenchment, resignation or closure of business. Deductions permitted from wages include deduction for fines imposed in the prescribed fashion, deduction for absence from duty, deduction towards damage to or loss of goods or loss of money by neglect or default, and deduction towards value of accommodation or amenities supplied under contract. Deduction towards recovery of travel or other loans and advances with interest. Deduction towards recovery of house building and other approved loans along with interest. Deduction of income tax and other statutory levy and deductions under a court order. And deductions towards subscription to Provident Fund, Pension Fund and health insurance schemes. The total deductions not to exceed 50% of wages, and wherever there is excess, it has to be done in a prescribed manner. Certain specific provisions in respect of fines. No fine can be charged except those which are specified or approved by government and by notice, and the notice specifying acts or omissions are exhibited in employment premises. No fine shall be charged until employee given opportunity to show cause against it, and on any employee, fine not to exceed 3% of wages for the wage period, and no fine to be imposed on anyone employed under the age of 15 years. Fine not to be recovered in installments. No recovery after expiry of 90 days after the fine was imposed. All fines to be recorded in a register in the prescribed form, and fine realized is to be applied on approved purposes beneficial to employees. Bonus provisions under the code comprise applicability, minimum and maximum bonus, allocable surplus, set on and set off, disqualification and inspector. Provisions as regards bonus shall apply to an establishment where 20 or more persons are employed or were employed on any day during an accounting year. In respect of establishments consisting of departments and branches, for computation of bonus, all such departments, undertakings or branches shall be treated as parts of the same establishment unless a separate balance sheet and profit and loss account is prepared and maintained for each department, undertaking or branch immediately before the commencement of the code on wages. Bonus provisions under the code are not applicable to employees of Life Insurance Corporation, to seamen under Merchant Shipping Act, to employees registered under Dock Workers Act, to establishments under any department of central government, state government or local authority, to employees of universities and other educational institutions, to hospitals, Chamber of Commerce and institutions not for profit, to employees of Reserve Bank of India, to employees of public sector financial institutions other than a banking company, and employees of any other establishment as government may exempt. The provision on minimum bonus stipulates that an annual bonus calculated at 8 1/3% of wages earned shall be paid by the employer to every employee drawing wages not exceeding government specified amount per month. However, he must have put in at least 30 days work in an accounting year, and the minimum bonus is payable whether or not employer has allocable surplus in the previous accounting year. In respect of maximum bonus, the code stipulates that where in any accounting year allocable surplus exceeds amount of minimum bonus, the employer to pay bonus in proportion to wages earned by the employee during the accounting year, subject to a maximum of 20%. Where wages of an employee exceeds specified amount per month, bonus payable to such employee shall be calculated as if his wage were such amount as fixed by appropriate government. For calculation of available surplus, the base figure will be gross profit for the year, from which will be deducted sums referred in section 34, namely depreciation admissible under section 32 subsection 1, direct tax payable for the accounting year, and development rebate or investment allowance or other tax relief also to be deducted. In respect of companies, from the available surplus will be deducted actual dividends payable on preference share capital, 8.5% of paid up equity share capital as at the commencement of the accounting year, and 6% of its reserves as per balance sheet as at the beginning of the year. The residual available surplus as multiplied by 60% is called allocable surplus in respect of banking company, and as multiplied by 65% will be considered as allocable surplus in respect of other establishments. Provisions regarding set on and set off. Where in any year allocable surplus exceeds maximum bonus under section 26, the excess over 20% shall be carried forward for set on up to and inclusive of fourth accounting year for use in payment of bonus. Where in any year allocable surplus falls short of minimum bonus, such deficiency shall be carried forward for set off up to and inclusive of the fourth accounting year in payment of bonus. As a matter of procedural priority, in calculating bonus for the succeeding accounting year, the amount of set on or set off as carried forward from earlier years shall be first taken into account. Allocable surplus shall be always after set on or set off under section 36. Bonus under any agreement or settlement, including minimum bonus, shall not exceed 20% of wages earned by an employee during the year, and in the first 5 financial years, bonus is payable only when employer derives profit without set on or set off. While paying bonus for any accounting year, the employer is entitled to deduct any payment made on puja bonus, customary bonus and interim bonus, and pay only the balance if any. Bonus is payable by crediting into bank account of the employee within 8 months from the close of the accounting year. However, government may extend the said period, and including the extension, the period cannot exceed 2 years. However, in case of award, payment has to be made within 1 month from the date the award becomes enforceable. Where an employee is found guilty of misconduct causing financial loss to the employer, it is lawful for the employer to deduct the amount of loss from the amount of bonus payable for that accounting year only, and the employee will be entitled to receive the balance. An employee is disqualified from bonus if he is dismissed from service on 4 grounds: fraud, riotous or violent behavior on the premises of the establishment, theft, misappropriation or sabotage of property of establishment, and conviction for sexual harassment. An employer is obliged by law to maintain a register detailing persons employed, along with muster roll, wages and such other details in a manner prescribed, and he is required to display an abstract of the code with category-wise wage rates, wage period, date and time of payment of wages and inspector details, and he shall also issue wage slip to employee in the prescribed form and manner. An inspector cum facilitator under section 51 is appointed by appropriate government to exercise powers in specified geographical limits. He is deemed a public servant under section 21 of Indian Penal Code. He advises employers, employees on compliance with the code. He inspects establishments assigned to him by the appropriate government. He may examine anyone for information he believes to be a worker. He can require a person to give away information within his power with respect to names and addresses of people. He can search, seize or take copies of registers, records of wages or notices considered relevant for an offence under the code. He can inform government on defects or abuses not covered by any law in force. And the inspector is entrusted with the power of a public servant to be provided with document or given information under section 175 and section 176 of Indian Penal Code